Um, I am Adam Jones. I'm the Chamber Small Business Council president this year. And this is a topic that we've had every year. And I do hate that we don't have people here because I think it's very important. Um, I don't see, before we start, we always like to thank our sponsors. I do not see Steve with Blue Cross, but how about Brad with the Fireflies? Brad in here? Nope. Okay. Well, we will keep on moving on. Um, One of our existing partners will have the opportunity at the end of the day to deliver a 30-second elevator speech. That's kind of our new door prize. So if you did not give your business card, please make sure you get one so you may have the opportunity to give your elevator speech at our next meeting. Um, so to the heart of our event, uh, let's dive in. I'm going to allow the panelists to introduce themselves, and then we'll go through a list of questions. We want to get started.
Sure. For those of you I haven't met this morning, good morning. My name is Bill Duda. I'm the office managing shareholder of Ogletree Deakins, Columbia, South Carolina office. We're right over here in the first base building on the fourth floor. Been here since this looked like the zombie apocalypse until it was all nice and built up. I've been practicing in employment law since 2000 when I graduated law school. Been in the same firm the whole time doing nothing but employment law. Prior to that, I managed Repco and CVS drugstores. So I worked a little bit before I went to law school.
Revco. That's it.
Repco, there's the blast from the past, right?
I'm Ben Means. I'm a professor at the University of South Carolina, Joseph F. Rice School of Law. I've been there since 2008. I focus on contract law, business association kind of issues. Most recently, for the last couple of years, I've been directing a program on family and small businesses. And before that, I spent about a decade practicing law. I was a litigator, and I focused on a lot of, well, one of the things I did involved small businesses. So that's something we might talk about.
Good morning. My name is Dayton Riddle. I'm an associate at Adams Bernstein. We're a law firm based in the Southeast with about 300 lawyers across 9 offices. I'm working out of the Columbia office, which is on Main Street. I practice primarily corporate law and also economic development law. Been practicing with law firm for about 3 years. Prior to that, I was with an international firm for office in Hong Kong. Looking forward to connecting.
Thank you. I'd say one of the things that small businesses, don't have, they obviously don't, most of them don't have the money for a general counsel and stuff like that. So I do think this will be informative. What are legal implications of different business structures, such as sole proprietorship, LLC, et cetera, and how should a small business approach that choice?
I'm happy to start with that one. So for me, as much as everyone likes to say that lawyers really like to sue, for me, the main goal is to prevent litigation and protect our clients as much as possible on the front end. So whenever we like to talk to people, especially those who are setting up operations or setting up businesses in South Carolina, the first thing that we talk about is, what their legal entity setup is. So for most mid to smaller businesses, we normally typically recommend setting up an LLC. The main reason why you do this is if you properly form it, properly operate it, and properly capitalize it, it prevents or extremely limits the ability for your personal assets to become liable in the event you have a loss. One of the major benefits of having an LLC is versus a corporation is that they're much more easy to operate, and then B, you're able to operate them as a pass-through entity. So they will flow through and often tax themselves as a partnership, but also providing that personal liability protection. The other thing that it does provide, assuming that your officers and managers and directors is a corporation, it allows for protection for them, indemnification protection for them for their actions, so long as they're maintaining their fiduciary duties. That's a high level. Does that answer the question?
I think so. I do have a follow up just for that. So, a lot of people when they just decide to start a business, they're going to start a sole proprietorship just because they might not know the implications. But I know my firm did this. You can go from a sole proprietorship to an LLC.
Absolutely. It's actually in South Carolina, it's very easy to form an LLC even after the business is started. There are some contractual things that you have to take care of to move things from a sole proprietorship to an LLC. But it definitely is something you should consider doing sooner rather than later. In South Carolina, it's literally filing a form with the Secretary of State. Now, it can get more complicated, like you have multiple owners or things like that. There are additional things that you should consider, such as an operating agreement, or things like that that can govern the actual running of the entity. But an LLC at its simplest form is it's very simple to set up, and it's definitely something you would.
Anybody want to add anything?
I'll just add for the group that nothing we're saying here is specific legal advice. And I agree that the LLC is increasingly the typical form that gets used because it gives the benefit of the limitation of liability and the typically advantageous tax treatment. But your circumstances might be different. And also there is the issue of tailoring the standard form to your needs, especially when you have more than one owner. You really have to be careful about doing it on your own. So maybe things in the standard form, yeah, you could fill it out. We could do it right now and go over the LLC, but you might be missing some things that could be important.
Small businesses as startups and existing as they grow, contracts are something we all sign and not something that you necessarily go to class for. So what are key elements of a legally binding contract that small business owners should look out for when drafting or signing contracts to negate potential legal pitfalls?
You're the contract professor.
Well, I'll give a very high level overview. And then maybe Bill will talk about some more specifics. And in general, to have a legally enforceable promise, as my first year contract students are learning right now, or will be this afternoon, you have to have mutual assent and you have to have considerations. You have to have a bargain. And I think that aspect is going to be pretty clear in almost any business contract you would enter. So the harder part of it is what exactly is the contract going to say? For business people, there is a tendency just to focus on the stuff you're going to fill in on what's the price, what's the quantity, what's the delivery date. And the other stuff, you need your reading glasses if you're my age. Doesn't seem to matter because those aren't really the terms of the deal, except that can be. So that is an aspect that I would say that getting into contracts, you do have to at least think about what's in the plan.
Yeah, I would just add to that. As the employment lawyer on here, I guess what I'll say about contracts generally for small business owners is, and look, my firm has nearly 1,000 lawyers. Okay, so we represent everybody locally and internationally. And I can tell you on both sides of that, particularly when you're dealing with a big contract, we call them you're dealing with a gorilla a lot of the times. It's a big, huge corporate entity, and they're going to give you a contract really of adhesions like this is it. This is our deal. If you want it, take it or leave it. And there's some pretty onerous terms in there. I've been on the other side of writing those onerous terms, and I've been on the other side of advising smaller businesses what they can do to try and negotiate themselves around them. The fail would be is to not be realistic about what is required of you if things go wrong under the contract. Look, the contract may be so big that it's worth the squeeze, but don't put your head in the sand over what can go wrong if the contract is breached or not performed on, because those terms were written in a way that's probably very advantageous to the larger company that you're dealing with, if that's the case. And I would just tell you to be mindful of that. The contracts I tend to deal with from an employment law standpoint, in South Carolina, still in at-will state, so we don't have a lot of employment agreements except with upper management, right? We do have non-compete agreements, which you may have heard are now still valid. The FTC's rule to strike those down was overturned by, of course, the federal court in Texas, which is where federal regulations go to die. So those things are enforceable. I would tell you as a business owner, if you feel like you get somebody in, you don't want to steal all your goodwill, steal your information, all that, get with a lawyer and insist that they have an enforceable agreement for you. The biggest overreach I see is I want an ironclad, 50 state, huge, don't do that. As your lawyer, what I would tell you is we need to go into court, tell the judge, we didn't even ask for everything we could have asked under this contract. We asked for a very limited scope, just enough to protect the business, to not make it where this individual can't go out and earn a living. And if you can go in and tell a judge that, they'll enforce them in South Carolina. And people around here would tell you, I hear they're not really enforcing it. That is not the case. If they're well written, reasonably tailored to protect your interests, the courts here in South Carolina will enforce.
That's a good point because I've heard numerous times that they're not enforceable. So,
It's because nobody's paying enough attention to writing them correctly.
okay. How can small business protect their intellectual property, and what steps should they take if they suspect infringement? And are there cost-effective strategies for small business to secure their IP rights?
I guess I can take that one. Admittedly, not an intellectual property lawyer, and unfortunately, cost-effective and the term intellectual property do not necessarily match together anytime. And I think you guys would agree with this. Anytime you specialize in a legal practice and in a very specific niche field, such as intellectual property, the prices go up. That's just a secret. Copyrights and patents. I mean, there's three types of intellectual property that you're probably deal with. For copyrights, patents, my recommendation is you need to go talk to a lawyer. Those are going to be very specific. They're going to be very tailored to specific things, and it's unfortunately going to cost a lot of money in most instances. 2 points I would make about patents and copyrights are, for patents, first and foremost, don't use anything that you think is a novel idea out in the public, because if you use it out in the public, tell people about it, if that happens, there's a real chance that you lose novelty, and by doing that, makes it unpackaged. So again, you need to talk to someone specifically about patents, but that's at a high level. The other interesting point on copyrights that I would bring up is regarding AI. The law right now for artificial intelligence as it relates to copyrights is shifting. But right now, the current understanding is if AI created it, you can't copy it because it's not an individual creative thought for you. It's a creative action by. So therefore, you need to talk to someone specifically using AI and consider wanting to copyright a particular creative work. For trademarks, there's a couple of different things. Trademarks are going to be your logos, your statements that make your business, identifiable to your customer, right? So the reason why trademarks exist is so that it helps prevent customer confusion, right? So the goal is you create a mark, you create a brand, you create something, and your goal is to make sure that your logo and your statement do not get confused with, someone else's. Now, there's two ways to really go after and again, at a high level, there's two ways to protect yourself. One is to go ahead and make filings either at the state level or at the national level for to register your trade. And you can do it in South Carolina. It's relatively inexpensive to do that. And you register your mark and your statement and you submit it in, and then the South Carolina Trademark Office will go through it, issue a trademark. Now, if you do it at the national level, it's a little more expensive. It goes to the U.S. Patent and Trademark Office, and then they can issue a trademark for you. They will run nationwide. Should I go into more detail, or? Yeah. Okay.
Yes, sir.
Yeah. In terms of infringement, in terms of if you suspect someone has infringed upon your trademark, even using the brand, you can go after them for that. But you're going to do that. There's a couple of things you need to make sure that you're looking. One is actual customer confusion, right? For instance, like if I was making a brand of athletic shorts and I called it Nike, well, Nike's probably going to come after me, even though it may be not exactly the same, but they're probably going to come after me because it's going to cause customer confusion, right? So that's the first thing. And the second thing we need to consider is priority, right? So whoever's using the mark first generally gets the right to that mark. So if you suspect infringement, you need to show customer confusion and priority, and then you would submit a cease and desist letter potentially to a given company. Now, when you hit the idea that you have infringed, definitely recommend talking to a lawyer at a high level. But I will say this, if you are maybe not the priority person, maybe you accidentally have been using it second, sometimes it's better just to be quiet. Because if you bring up something and then it turns out that you're not priority, then you're going to have to rebrand it. You're going to have to lose the ability to use it. So it's just something to consider. Maybe sometimes it's better not to act and to be quiet at a high level. But there you go. Super high level overview. And I did that very quickly. So if you have questions on it, I can answer it after.
I'll tack up on just a couple things. Number one, I can't think about trademark and brand recognition without thinking about Coming to America. Y'all remember that? McDowell's. I'm not McDonald's, I'm McDowell's. That's always my favorite one. But then, and again, without going into detail, this is where I would refer to one of my other lawyers in my firm to help me with this. But when you're bringing people in, if you have intellectual property you want to protect on the way in the door, existing intellectual property, as much as we don't have employment agreements, you are going to want your employees in that instance to sign a confidentiality agreement and acknowledgement that there's certain kind of information that needs to be well defined, that they're going to keep confidential, not take with them and use when they leave. Trade secrets are good to reference, but there's already a state law that protects them if you don't have an agreement. And then the other thing you might want to consider too is if your business is the type that's going to be developing intellectual property while that individual is working for you, that they assign anything that they develop while on your dime to the company. Other than issue spotting those two things for you, I can't tell you how to write it, but I can tell you to go find a lawyer who can, and I can help you find one. It's not me, but that's the kind of thing you want to protect that company.
Okay. This will go to the employment lawyer. What are the most common employment law issues small businesses face, and how can they ensure compliance with both federal and state law? And what steps should a business take if an employee sues them?
So this is a big question. I would love to hear from you guys. I mean, I've got some things that I tend to see in my smaller businesses, and it tends to be a little more nuts and bolts rather than your kind of garden variety discrimination, retaliation, harassment claims. And I'm going to blow past those. Those are culture things to a large extent. The one thing I will tell you about all of these things, particularly when it comes to those type of treatments and those type of lawsuits, check your culture. I hate to go off the legal script, but it's just like anything else. If you have a good culture, good open communications, good ways for people to report things that are going on, access to people who can make a difference in the way things are happening, that's going to solve a lot of your problems before they become problems you have to deal with from the standpoint of discrimination, harassment, retaliation claims. You want to publicize those policies and then remind people about it from time to time. Setting that aside, that's a big, huge category of cases. I just don't see them in small businesses as much. What I see are wage and hour law violations a lot, South Carolina and federal. For example, one of the ones that I see a lot is raise your hand. I can either poll the audience or I'll just tell you there's a law in South Carolina that requires when you hire somebody, you tell them in writing some fairly basic but key terms and conditions of their employment. It's got to be in writing. It's got to be provided to them. It doesn't have to be signed. But did you all know that? Do you have that on every employee that you hire? Probably not. Right? And then that employee doesn't like this. Then you'll get into things like, so that's number one. That's South Carolina payment of wages law. So in writing, when they start, the idea there makes sense. If you're going to hire somebody, they need to know what their normal hours are going to be, what their pay is going to be, how they're going to get paid, when they're going to get paid. These are all things outlined by statute. And that's only fair that you tell them that when we start. Then the law is also, if you're going to change any of those material terms, you give them 7 days written notice before those become effective. Why? So that they can make a decision to show up on day 8 when those things become effective. All right? It's fundamental fairness in that, and it's in writing so everybody's clear. So I see that one violated a lot. The other one that's in there too, along with South Carolina law, is our improper deductions. Somebody, the one I hear all the time is, well, Bill, they left and they took the computer. I'm going to hold their last paycheck until they return it. That's illegal in South Carolina. You can't just hold a check. You can't take deductions from a check you hadn't told them 7 days in advance you're not going to take. So you can't just up and say, I'm going to hold this check hostage until you bring me back my equipment, my uniform, my keys, my car, my computer, my phone. So then you got to put some things in place before that. But I see people violate that all the time because that's the leverage you got in that situation. And with remote work these days and allowing people to be flexible, they've got a lot of your equipment in their personal possession away from your offices today. So I see that one a lot. Under the Federal Act, which is the Fair Labor Standards Act, I see a lot of automatic breaks or kind of generalized timekeeping. a lot of 9 to 5s on the timesheet when you know full well they're not there at 9 o'clock every day and they're not there at 5 o'clock every day. And then if those are what your time records reflect, you're really vulnerable to claims by your employees if you're really not paying them for all the time that they work. I always get there at 8:30. I know I'm scheduled 9 to 5, but I get there at 8:30 and I start working right away. And that's all well and good when everybody's happy and likes each other. But then as soon as something goes wrong, that employee's out the door and maybe they've gotten a workers' comp claim by now, or they go see a lawyer, and the lawyer starts asking them questions. How'd they pay you? Tell me about that. Now, maybe you've got a half hour on either side of every day that you didn't account for. So I see record keeping, timekeeping kind of errors in that regard quite often, making people stick around before shift, after shift, and things. If you're requiring them to be somewhere and you started their workday, that can be a problem. I guess the other one that I'll add here that I see a good bit because it's challenging are accommodations of all kinds, whether or not that's for pregnancy, childbirth-related conditions now, or disabilities. A lot of small businesses now, if you've got 15 employees, if you've got less than 15 employees, that's not going to be something you have to deal with. But if you have 15 or more, then that's going to be the ADA and South Carolina Pregnant Workers Accommodation Act. A lot of times in those situations, somebody comes to you and you're a small business and they have limitations and you just think it's going to be too hard for you to deal with. And you might be right. The problem that I see is what the law requires in both instances is an interactive conversation with the employee. And if you take that step, most times, if there's really not a fix, the employee will agree with you. Like, look, man, this is your job. Look, man, this is your job. This is what your limitations are. I've thought about how we could try and make this work for you, and we don't see a way. But you're the one who does the job every day. You're the one who does it. You know how you feel. What do you think? If you do that, and they give you a good answer, you ought to pursue it. But oftentimes they'll just agree with you, and then it becomes a matter of how you address the fact that they're going to be unable to work for a while. So those are things that I see small businesses miss on. The first part of kind of your basic blocking and tackling, how we keep wages and time. And then the accommodations are, and I will just tell you this, that the most sophisticated employers across the country have problems with accommodations. It keeps me busy. No matter what presidents in the White House, no matter what's going on, accommodations are the challenging thing, and even more so for small business because they typically don't have a dedicated HR person. Probably got a frontline manager trying to deal with that accommodation, and that's just challenging.
I don't know if y'all got these in advance, but there's kind of a follow-up on this. If an employee sues, what are the immediate actions should be a business owner take? And what preventative measures can you put in place to minimize risks of lawsuit?
Yeah, so let's start with preventative, right? I like to talk about preventative medicine and surgery. It's much better to keep yourself in good shape than to try and stay healthy than to deal with all the pain, aggravation, money, and time loss that comes with the surgery. Really no different in the employment context, right? If you stay ready, you don't have to get ready, that kind of thing. So the biggest thing you can do to mitigate risk before it happens is have that kind of culture where there's openness and good communication and clarity with your employees about what's expected of them, whether or not they're meeting or not, and then a fair chance to get it right if they're not. If they complain somebody's harassing them, look into it and put a stop to them. I mean, that's some basic blocking and tackling stuff, but as a small business owner, you're so overwhelmed with so many other things, it's easy to kind of brush those things aside. But man, that's an investment of time you need to make on the front end if you can, because the back end time, money investment is just huge relative to the small investment you have to make in the beginning to prevent it. If you do have an employee who threatens a lawsuit, one of the other questions I think that we want to discuss is what insurance is available. There is employer practice liability insurance available to you. You should talk to a broker about that, what it entails, what your deductibles are, how much it costs. But having that in place will do two things. It'll probably get you cheaper rates from the attorneys who do your work, because you'll need an attorney. Representing yourself in these things is very challenging. And it'll also cap the damages that you'll have to pay typically. And then, gosh, get a lawsuit, I would tell you, number one, secure all the documents you have relevant to it. I mean, a lawyer will tell you to put a legal hold in place, which is notifying anybody who we would call a key player, people who have information about what's happened with that individual, what they're alleging. They're notified that, hey, we've gotten a letter that requires we secure all information about Bill and the end of his employment and any number of such subjects. So can you grab everything that you've got currently, partition it off somewhere, send me a copy of everything. You gather it up too, so that way you're secure and you took the first step, which is securing all your relevant information. If you destroy it, you'll get a jury charge against you and it'll bear you a trial. So first thing is securing all your information for sure. And then even if you're not going to go the route of a lawyer, because look, we're expensive, which is all the reason for preventing this to start, at least do a consult with a lawyer about the lawsuit. Spend a couple, 2, 3, 4 hours for that lawyer to understand what's going on, meet with you, and at least talk about what you're facing. You may be able to negotiate a resolution with the individual who's looking to sue you. And then be realistic. Ask that lawyer to help you be realistic about your chances of success and how much it's going to cost to win. Heck, sometimes how much it's going to cost to lose. Because everybody, I mean, I will tell you that in my chair, I see everybody really, gets aggressive and wants to fight. And that all really tones down a lot when we talking about how much it's going to cost to be right. And I can't help with that. Occasionally we get cases dismissed once they're filed. That's rare. And even winning a lawsuit is a very, very expensive endeavor. I mean, you're probably looking at, in almost every kind of employment case, at least between $50,000 and $100,000 to get a case dismissed at some degree, if not more. And that's insured or not.
50 to 100,000?
Yes, just that, and that is to get a case dismissed at what we call summary judgment, which means after the close of discovery, which is where we take all of our witness testimony, exchange all our documents, we go before a judge, we say, Judge, even if you look at all the facts and evidence before you in a light most favorable to the plaintiff, even if you look at it that way, under the law, we win and here's why. And as an employment lawyer, that's our bread and butter. That even to get you to that point, the first thing I'm going to get, folks, is how much is this one going to cost? And if they've not done this before, once I put the price tag on it, people get realistic about how much they want to fight at that point. Because, and the other thing I'll tell you got to consider too, is you're already a busy small business owner. How much time you want to invest? How valuable is your time, your manager's time, the employees' time are going to be witnesses? It's not a good situation to be on the other side of a lawsuit. So hopefully you do what you can to prevent yourself from being put in that position. And when you get it, be realistic about what the future holds. Because you don't want to become an ATM where every employee you ever let go comes calling looking for a nuisance value settlement. But at the same time, hopefully for you guys, lawsuits are going to be few and far between. You need to make a really good informed decision about how you want that case to go forward. And the best time to resolve them is early. Before you spend a lot of money defending it, only to decide to settle it once you're knee-deep in legal fees, wishing you just settled it at the onset. So that's a conversation that I would encourage you to have with a reputable lawyer who knows what they're talking about in the space and will be realistic with you about not getting the case in and working it to death, but what's it going to feel like for you as an owner if we go this route or that route, or maybe 2 or 3 other routes too. But that would be what I would tell a business owner to do in that scenario.
Yeah. And excellent points. The one thing I would add on top of that is pay attention to deadlines. I know when people receive a lawsuit, they're going, God, I don't want to deal with this right now. Like, I've got 6 other orders I need to get done. Deadlines, the courts, are normally, sometimes they're pretty flexible, but you want to be hitting your deadline. So the sooner you talk to a lawyer, the better. Because one of the biggest things I deal with when I have, especially with my international clients, is things will hit my desk 3 days before the deadline to respond. It gets more expensive, more cumbersome, and more difficult for everyone the shorter time frame you give your lawyers to act. So if you receive a lawsuit, any type of lawsuit really, but especially an employee one, you need to reach out to a lawyer sooner rather than later. And notify your insurance carrier sooner rather than later.
And just so you know too, if you get served with a lawsuit, there's on top of the complaint will be a summons. The summons will tell you how much time you have. It's going to differ how much time you have to respond, whether or not you're a state or federal court. So pay attention to the summons. Don't just brush it off as a legal paper. Read it. It's going to tell you how long you have to act. And the consequence for not answering that complaint in time is what's called default. You're held to default because you didn't answer in time. And what that means at that point is, for all intent and purpose, the liability alleged against you is established unless the court lets you out of that. And then it becomes a matter of you get to defend yourself a little bit, very little bit on the damage calculations at that point, unless it's laid out explicitly in the complaint. But that's a tough road to hoe. I will tell you that in South Carolina, a lot of lawyers will let that slide, but you can't always. Sometimes your client won't let you. But we're collegial enough with one another where oftentimes it's like, hey, I got this complaint. I just got it yesterday. Can I get 30 days to answer? 9 times out of 10, the other side is going to say, yeah. But that 1 time out of 10, you're sitting duck. At that point, liability has been established and you're trying to figure out what your damages look like. So huge consequence to not getting that complaint answered in time. So definitely pay attention to that if you get served a lawsuit. Great point.
I had just a general point connecting intellectual property discussion and employment law discussion, and a lot of what we've been talking about. It's really important to have a lawyer involved early before you're making decisions, before you're licensing your product to the grocery store, before you're embarking on hiring employees. And certainly if something comes up, there's a dispute, there's something you're worried about, having a lawyer on your team along the way, even just for 2-hour consults here and there as needed, can save you a lot of time and money on the back end because you didn't do something. And now you may have lost your trademark, or now your employee may have a claim against you for one of those things Bill was talking about. That would be, I think, a general point all of us would say is lawyers are an important part of the team. Yeah, they're expensive, but a wise investment early on can really save. And again, if things are going well, if you get along with that grocery store and there's never a dispute, who cares? If your employees love you and they love each other and there's never any dispute, it doesn't matter. If your co-owners get along and you can agree how to share control on the financial returns of the investment and any debts, you don't need lawyers. The problem is when you can't agree, then you find out what's in the fine print. Then you figure out what you should have done. So that I think that will be the general takeaway.
Yeah, one really good point to add on that too about getting a lawyer involved early is you're going to need to investigate what happened, regardless of what this employee has said, right? And if you don't get a lawyer involved and you start sending emails to everybody about what happened, you know what you're doing? It's creating new evidence. Okay. The one thing that's good about getting a lawyer involved early is, say, use me as an example because I'm sitting here. Bill, I got this lawsuit, yada, yada, yada. Okay, I'm going to need you to collect some information so that I can render some advice to you as to what your liability is. So go off and collect these things from it. That collection, that communication is essentially being done at my direction. We can claim privilege over that. In other words, you're allowed to circle the wagons with your lawyer, discuss and communicate over what's happened in that case without it being subject to discovery. And that's going to be a key thing at the onset too, before you go shooting off a bunch of emails and doing things to respond to the lawsuit that are going to be discoverable. You get a lawyer involved early, and that's done at my direction or at a lawyer's direction, then that collection of information, that investigation will be done under privilege so that you can have a better view of what you're facing without creating bad evidence against yourself.
So small businesses a lot of times have to deal with license and permits depending where they start up and if they move into different counties and who they're hiring. To ensure compliance, what local statutes and federal regulations should small businesses pay attention to, and what are consequences of operating without necessary licenses?
That's a difficult one.
I think this is a panel punt to a certain extent.
Good. Sounds good.
Well, and by that I mean we just don't work in the area. And the mark of a good lawyer is one that tells you what they don't know rather than acts like they know everything. So we got a bunch of good lawyers up here, so we're not going to tell you something we don't know. I mean, I will tell you, though, South Carolina LLR is a really well-run, good, helpful agency. Dealing with them from the wage and hour division and whatnot, I can tell you that them, in addition to do, are agencies who really look, in my view, to partner with the public and to help the public get things right. And they've got really good resources now and really helpful people. So I've sent a lawyer who already knows the ropes, which none of us do when it comes to licensure, candidly. You've really got a good resource in our state agency for that regard. Other than that, you'd have to find a lawyer who's got some knowledge and expertise in it.
Yeah, I would add that on top of what you said, licensing and regulations, those are very business specific. Something that is for a construction company is completely irrelevant for a grocery store chain. So that's where you want to be, speaking with LLR. I'm actually on the phone with LLR probably once a quarter with a random question that my client has. So it's definitely a resource. They're very nice people, and would definitely recommend having that conversation.
And I'd say reach out to City of Columbia and Richland County Small Business Office. I mean, they're a wealth of knowledge on what licenses you need to operate and stuff like that. I'll say working with engineers, I do know if you practice without a license, you can get a hefty fine, public reprimand, have to pay their legal fees, and it's not something smart to do.
Yeah, and circling back on one thing I mentioned earlier, if I said, hey, have you given all your employees in writing in terms of employment notice? If you haven't, go ahead and fix it. they're on South Carolina LLR has a great form on their site. It's the easiest way to comply because it's got blanks to fill out. And if they see that you fill it out, they're going to be good with it. And candidly, if they come in and you didn't do it at the onset, but you fixed it since, typically on your first pass with them, that's all they're going to ask you to do anyway. If they know you haven't done that, they're not going to fine you typically. They're going to say, look, you need to get this straight and get it straight across the board, and then just implement it as something that goes into your day one orientation with the employee, where with making them an offer, give them the term sheet too. Okay, so that's something, again, just to harp on the fact that they're not there to punish you. They're here to help you get it right and protect the public at the same time. I'd go ahead and self-correct that now if you haven't already done it. And there's a great form on LLR's website specifically for that purpose.
Very good. How can small businesses limit their liability to protect themselves from potential lawsuits, and what types of liability insurance would you recommend they carry?
I can talk about that one. So the worry here is something called veil piercing. If you set up a limited liability entity, what that means is you're not exposed to personal liability. It can't come after your bank account just because something went wrong with the business, as long as you yourself didn't do it, assuming that you have maintained the separation of the business. And if there's liability the business can't cover, the plaintiff's lawyer is going to be looking for a way to sue you personally. So you need to think about running your business in a way that keeps it separate from your personal affairs. That's a very hard standard for a plaintiff to overcome, but there's some things, easy things you can do. Don't commingle your assets. There should be a separate business bank account. There should be a separate personal bank account. The legal standard, again, this isn't legal advice, but basically in South Carolina, what courts are looking for is, first, is there any separation between you and the business? Or is it fair to say that the business is just a sham? It's a dummy. Everything it does, you completely control, not for any separate purpose, but for your own. And then second, if that's true, have you been running it in a way that's tantamount to a fraud? You see that employee has filed a lawsuit, and the next day you drain the business bank account and shift it over to your personal bank. That kind of thing. Leaving the business as a shell so there's nothing there for the employee to sue about. So again, talk to a lawyer, figure out what you need to do. But I think most courts understand that small businesses are not going to have the wherewithal in terms of formalities to do what a public corporation. And that's fine, but there's still some basic things you do. If there's some formalities, comply with them, don't commingle assets, and just make sure you're treating this business, which you own and control. And you might be the only owner, that's fine. But just make sure you're recognizing it as a legally distinct entity, you and your personal affairs. Don't pay your kids' dental bills out of a corporate bank. That kind. On the insurance point, it would really depend on your business. There's some things you can consider. There's something called key person insurance, which is insurance the business pays to create a fund if there's going to be a transition of ownership to pay out the person who's leaving or has died. There's cybersecurity insurance, which has gotten very expensive these days, but if you're worried about data privacy issues, there might be a policy. COVID, there were a lot of business continuity issues. There are insurance policies that'll help cover payroll for a period of time. So depending on what you're worried about, what you can afford, there might be insurance that'll help cover some of those gaps.
The only other thing I would add, and this is going to be a business specific consideration, is whether or not you want to, either as an occasional or a regular thing, do severance agreements. You're going to let somebody go. Maybe give them a week's pay for every year they've been with you or something like that. I wouldn't necessarily suggest you set up a plan where everybody gets one, because there's going to be people engaging in misconduct you don't want to give any money to. But look, you got to recognize too, if you're going to go and tell somebody that their employment with you is over, you're putting them in a heck of a situation, right? They got to go home and tell their significant other, their kids, that just happened, and they're going to figure out how to pay their bills, and put them in a desperate situation. And I deal with it all the time, but in that same moment, you may be able to give them a bit of a bridge to the next thing if you consider a severance agreement that comes with a release of liability. Get advice from a lawyer about the extent of that release. There's some releases that don't necessarily cover some of the things I said are problems. Wage issues. There's a I would say we're trending towards people being able to privately assign those away, but that's still a debatable issue across the country on a federal level. And the state statute suggests you can't waive away those rights too. So get some advice on the extent of that release and how good it is. But that would be something to consider as well. A couple weeks pay may also be something that makes you feel good. Sorry, we've got to let you go. This hasn't worked out. Here's a bridge. In order to get the bridge, you do have to sign a release, but we're at least willing to offer you this. And they can always reject if they think it's a bad deal. But then if you get that signed, typically you won't hear back from that employee. And if you do, you've got a release to protect you from most claims that they might have against you.
One thing, sometimes your employee, somebody who's employed, is also going to be a co-owner. So another thing you need to really watch out for in small businesses, if you're the control person, is something called the corporate setting, minority shareholder oppression. If somebody has an equity investment, they own a piece of the business, you need to be really careful about how you treat them. And they might be a disaster to an employee. There might be a reason you have to let them go. They might be causing trouble in the business, but you want to be the reasonable person. You don't want to be going to court and having their lawyer be able to say, look at all the first they fired me, then they changed the company's dividends policy. They wanted to make sure I would get nothing and they get everything. You don't want to handle it that way, even though you may be legitimately unhappy, may be legitimately angry with what's happened, but you need to work the right way. So that's another situation where getting some legal advice on the front end can help you manage a situation that can turn ugly very quickly, especially where they're family dynamics. A lot of small businesses are family owned, and then your co-owner and your employee is also related to you. And that just is going to amplify the emotions and make it much harder to resolve amicably. People are going to be a lot more inclined to sue when they're unhappy. And you want to try to manage that situation.
Yeah, the one thing I would add on that is, yes, if you are going to potentially offer an employee equity in the business, it's absolutely vital that you have an upfront conversation with the lawyer so that all the documentation can be set clearly and adequately. The last thing you want is a fight over the ownership between the disgruntled employee and a business owner. That is not fun and it's going to be expensive. So it's better to set out the key plans. Normally you would set that out either in an operating agreement or a shareholder agreement. That's going into more detail. Definitely something.
Okay, we have time for a couple questions. Anybody from the audience got something they want to ask? Yes.
I mean, there's a trade-off there, and you have to be realistic about what you can afford. Just be aware that a standard form may not fit your business. You want to read it carefully. You may not want a bespoke drafted from front end to back end contract that a lawyer might do if you're not selling your business. It's just a routine thing. But it might be worth running that form by a lawyer and saying, take a quick look. Is there anything here you're worried about given my situation? So then, in other words, there might be a compromise position. It saves the time and just try to minimize the lawyer's time, but make sure if you can that you're having somebody look at a form you're going to be using every day and it'll be fine until there's a conflict and then you find out there's something in it that's very unhelpful that you could have avoided. Yes.
Non-disclosure agreement. I mean, typically something that's a trade secret, just using that as an example, stays a trade secret until it becomes publicly knowledgeable. In other words, if you can discover it through legitimate means publicly, it loses its protection anyway. So, I mean, I would tell you that something's a true trade secret or something but you're talking about a non-disclosure agreement. I view that in the context of business information. I'm not talking about like, hey, it's Justin Bieber's party, sign an NDA and don't talk about the party when you leave. We're talking about business information like that. I mean, I think those can exist in perpetuity until they're either obtained through legitimate means or they become public information. I don't think there's a time limit specifically on those. Like there would be, for instance, for a non-solicitation agreement or a non-competition agreement, which need some kind of temporal scope to them, some limitations. Non-disclosure, I mean, there's not a point in time where you get to act on somebody else's secrets unless they become public.
Thank you to our panel. Thank you to our panel. A lot of great information. This probably could be part 1 and 2 because we had more questions, but ran out of time. I'm going to turn it over to Naomi for the door prize, and thank you everyone for coming.
Yes, please. If you have any more questions, I'll pass the microphone to you. Is there any last questions for the panel? No? All right. Well, thank you to our panelists. Please give them a hand. And as Adam said, my name is Naomi Walton. I am with the Chamber Director for Small and Minority Business. And now we can move into our door prize. What I'm going to ask for you guys to do is to please take out your business card, pass around this bowl, and we have a beautiful gift here from Palmetto Federal Citizens Credit Union that I want to give you guys. So take those out, and I will pass this bowl around for you, and we will collect for the door prize. Thank you. While Laura does that, I'm going to give you guys a couple of closing announcements here. And I do want to say thank you again to our panelists. As you guys know, and as they've mentioned, they will be very expensive if you guys want to go ahead and hire them outside of today. So thank you all also for making it out this morning. I know traffic was a little bit tough to get here, but we appreciate your involvement with our small business breakouts. Following today, we have our military outreach at the State House, and that is led by Susan McPherson. So if you haven't made it out to our state fairgrounds for military outreach, that is going to be at 2 o'clock today. So I hope to see you guys there. Also, we have our applications open now for our Midlands Minority Business Accelerator. As you guys were checked in, you guys probably saw this at the front. Applications are open if you are a minority, woman, or veteran-owned business, or you know somebody who is and they want to scale their business. Please grab one of these. You can get my information. You can ask me about the accelerator, but we want to get this information out to as many people as well. And lastly, we have our annual gala Under the Lights. We just announced the location for that. So if you guys are interested in joining for our gala, we'd love to have you. Please see any of Chamber staff, Laura, Amy, or myself, and we can get you some more information on our annual gala. And with that, I'll go ahead and pull for the door prize. You want to grab one for me? Yep, don't look. All right, we have Kayla Jordan. Woo! So, Kayla, you have won a beautiful Palmetto Citizens Federal Credit Union Yeti Cup, also a gift card as well. And lastly, you guys, please don't leave without talking to our panelists, talking to one another, meet someone you haven't met before. And also, please visit our resource table in the back. We have Miss Kalina with the City of Columbia and Miss Margaret back there with Richland County. So thank you all again, and y'all have a great rest of y'all's day.